Welcome back to an exciting new episode of the Gateway to Data Protection and Privacy Special Series presented by EVA India Insights podcast. I'm your host, Pallavi, and today we have an enlightening topic on our agenda: the profound impact of 2023 Data Privacy Act in the telco sector. Joining us once again is Mini Gupta, our industry expert and cybersecurity consulting partner at EVA India. She comes with over an impressive 2 decade long career in risk management, and her expertise spans across diverse sectors, including TMT, manufacturing, media, and financial services. She's currently actively leading the 2023 DPDP Act agenda for EVA India, and she's also working closely on this agenda of data privacy in India and globally. In this episode, we discuss about the role of data fiduciaries, cross-border data transfers, and consent for IoT services involving multiple data principles. Minnie, welcome back to our podcast.
Thanks, Pallavi. Pleasure to be here.
To begin with, the telcos today are trying an ecosystem play by partnering with other service providers such as OTTs. In such cases, is there a primary data fiduciary or multiple ones that the data principal needs to deal with?
So, Pallavi, in this case, there are several and multiple data fiduciary specifically in this scenario. So, for example, if I'm a telecom subscriber and have provided personal data to the telco only for telecom services, then the telco becomes a data fiduciary. Now, if this telco has a tie-up with an OTT platform provider, then telco will obtain consent from the data principal to share their personal data with the OTT service provider for the OTT related services. Now, once the personal data is shared for leveraging OTT services, any additional data that the OTT service provider collects, such as any data required for account creation, in terms of their contact details, email IDs, etc., then the OTT service provider will become the data fiduciary for the additional data that they have collected, as they would then be deciding the means and purpose of that. So hence, in this case, both the telco as well as the OTT service providers would be data fiduciaries, and hence this is a scenario of multiple data fiduciary for their individual services and processing of personal data.
Thank you, Minnie. Adding to that, the Act currently does not allow personal data to be transferred out of the country, except in specific cases. Does the telco qualify among those who can transfer data outside the country, given that sometimes people travel abroad and the telco needs a cohesive picture to be able to customize their services?
So the Act allows for transfer of personal data outside the country unless central government by notification prohibits transfer to certain countries. Now the rules will of course let us know what those countries in the negative list would be. However, in the case of a telecom service provider, when the data principal uses roaming services, the data principal during roaming leaves the telecom provider's network and latches onto the local telco service provider network. In this case, what happens is that the law of the land is applicable, and any processing of personal data that is happening is still taking place within the home country. So while a data principal might be roaming, their personal data such as a call data records, etc., are processed in India only within the telecom provider systems. However, if we see the other way around, where a roaming user comes from another country to India, and then the data has to be shared back with that country's service provider. And if that country falls under the list of blacklisted countries for data transfer under DPDPA, then such transfer will not be governed by DPDPA, but by the Global GSMA Act that is agreed between all telecom companies globally for transfer of data in case of international roaming. So, when the roamer is going from here to outside, it's still, it's not something that we will need to transfer data for. But when an external or a foreign individual is coming to India and roaming in India, then it's really the GSMA Act that would apply.
Thank you, Minnie. Now, we see that there have been multiple cases of a breach reported where people have been misusing someone else's Aadhaar data to get mobile connection. How is that tackled in the current Data Privacy Act, or will this be notified later on?
There is no specific provision for misuse of personal data provided in the Act explicitly. However, this scenario may be considered as a data breach, and any data breaches have to be reported to the Data Protection Board as well as to the individual whose data has been breached. So if it comes to the notice of the data fiduciary that someone is trying to use Aadhaar of someone else, basically a case of impersonation, to get the mobile connection, and they are aware that the person sharing the Aadhaar is not the intended recipient of the service, then they can deny the services as well as report such breaches to the relevant authorities for impersonation. Furthermore, the Act does provide a case wherein, in case an individual is trying to impersonate, which basically means they're trying to violate a data principal's duties, then there is a penalty on the data principal for attempt of impersonation. So that again is something that can go against the personnel who's trying to misuse someone else's Aadhaar card.
Thank you for those insights, Minnie. Now, we see that most apps today ride on telecom services, which includes multiple players, and their server lies abroad with another e-commerce player. All these collect data and from the data principal. Does this complicate matters, or does the DPDP Act explicitly have provisions for all of these multiple scenarios?
The Act clearly provides definitions for data fiduciary and data processor. In the entire ecosystem of personal data processing, the data fiduciary, who is the primary source for collection of personal data, has to determine in the life cycle of personal data if there are multiple other service providers to which the data may be flowing, and what is the role of each one that service provider is playing. Now, again, it is a responsibility of the data fiduciary to ensure that such data processors are adhering to the provisions of the Act. Because if you look at the entire Act, the entire obligation is on the data fiduciary and not on the data processors. The data processors primarily will be governed by the contractual clauses that they sign between the fiduciary and the processors. So hence, it's important for the data fiduciary to identify all such processors as well as ensure that the relevant safeguards and clauses are put in place when engaging with data processors.
Now, adding to the topic of the data misuse, there is a provision for fines for a data fiduciary who fails to protect the data or misuses it. But how does that help someone whose data is being misused?
So while there is no provision in the Act that mentions, how to compensate or help someone whose data is being misused, and globally that's not a widely accepted practice either, which allows the data principal to be compensated. However, it is up to the Data Protection Board that we are expecting to be set up very soon, who will decide if they would like to impose a penalty on the data fiduciary and if there would be a compensation in return to the aggrieved data principals. Further, while there is no explicit provision, but the very fact that there are fines imposed on the data fiduciaries also act as a deterrent to ensure that the data of an individual or a data principal is not being misused. So there are deterrents for avoiding misuse, but direct compensation is something that probably will be taken on a case by case basis by the Data Protection Board, and then it would be decided.
Thank you, Minnie. Now, shifting towards the regulatory side, as these laws serve as an initial step, What is the institutional capacity being built to ensure that the law is being monitored carefully? In case of a data breach that harms a data principal, will there be a separate agency to take it further, or will it be going through normal police channels?
So data fiduciaries are required to notify data breaches to the Data Protection Board, as well as to the individual whose data has been breached. Now, in most cases, if you look at it here, there is a level of escalation provided. So in case of a data breach that harms a principal, one, the data principal, of course, can go to the fiduciary directly and request for what went wrong. They can take it to the data protection board. There is a provision to take it to further in case the principal is not happy with what the data protection board is responding. Then there is a provision to take it to TDSAT as well, and a natural progression or an escalation point from the TDSAT then becomes our Honorable Supreme Court. So yes, there are multiple levels of escalations that are provided that a data principal can go through in case of a breach scenario.
Thank you, Minnie. Now, we would like to note and ask about the Act. The does not talk specifically about the applicability of on an Indian national or a citizen or a resident. So then, in such cases, if an international traveler visits Indian territory, even for a day or even for few hours, then will the DPDP Act be applicable to processing of personal data even for that short duration?
So as per the Act and the applicability, in such a scenario also, ideally the Act will become applicable and processing will fall under DPDPA because it talks about the personal data within the Indian territory. We will have to wait for the rules which are expected in shortly within few days to see if it differentiates between processing within the territory of India and Indian citizen and resident or national, as well as the duration for which the processing takes place. But for now, basis what the Act has indicated, this scenario would come under the purview of DPDPA till we receive further clarifications.
Thank you. And lastly, we have if a telecom service provider is providing IoT services, and these IoT services are leveraged by multiple data principals within a household, then whose consent will be required to be obtained for processing of personal data? Do we need to take consent of all the data principals leveraging these IoT services that process personal data, or multiple data principles?
So globally, as far as if you look at the erstwhile CCP or the California Consumer Protection Act, there is a definition around household and caters to processing of personal data of household. However, under DPDPA, there is no such household that is defined. So in case of such a scenario where processing of personal data is taking place in IoT services, the consent of the data principal who opts for the IoT services will have to be obtained. This consent would act on behalf of everyone who is using these IoT services within the household. A privacy notice will have to be provided specifying all the purposes of processing that is taking place for these IoT services. But primarily the personnel who's actually taking the services will be the one providing the consent.
Thank you, Minnie, for sharing all those insights on how the new DPDP Act impacts the telco sector. Thank you for joining us for this
Thank you,
podcast.
Nandini. Thank you.
On that note, we come to end of this episode. If you would like us to explore other such topics on data security and privacy, please do leave us some suggestions that you would like us to deep dive into. Thanks for listening in. Until next time, this is Pallavi signing off.